the whole point of the Chapter 11 plan is to do, in essence, a financial restructuring. So what we want to have in our Chapter 11 plan is a way to make the debts manageable. And perhaps the most important thing that a Chapter 11 buys for the debtor is the most precious thing in life, and that's time. So if you have creditors that are chomping at the bit, they're beating your door down, metaphorically speaking, of course, although there have been some horror stories where it wasn't metaphorical. In any event, it buys you time, but it doesn't buy you income. And it doesn't make the debts just evanescent into the ether unless you've got just the right facts and just the right kinds of debts. So somewhere along the line in that plan of reorganization, you're going to have to come up with a way to service those debts in a way that's manageable. So the financial restructuring is the heart and soul of what's going on here. How do we do the financial restructuring? Well, there's different paths that we can take depending on the facts of the case. Sometimes we can show that there's been a change of circumstances, the income has gone up, and as long as we can get time using that increased income, we can service the debt. So one of the first things I ask a potential client who's considering a Chapter 11 is, what's changed? If you've been unable to service this debt as it is now, and you're going to be able to service it in the future, perhaps at a reduced balance, perhaps at a reduced interest rate, but what's changed that's going to make it possible for you to do that in the future? Because sometimes someone will call up and say, oh, I watched your video, I want to do a Chapter 11 and take care of my debts. And after we chat for a while, there's one of those, let's come to the world of reality sessions where you can say, look, you simply don't have the revenue to make this one work. Maybe we need to think in terms of shutting this business down. But anyway, one direction is to come up with enough income to service the debt as the debtor marches into the future. Now, just pie in the sky stuff is not going to work. We have to show the creditors and the judge that this is really a feasible plan, that we've got something that can work. We have a genuine exit strategy. So typically we like to come up with past profit and loss and a description of what the change in circumstances is that has changed that. So now there will be this increased revenue in the future. And the documentation has to be fairly detailed and accurate. So we're looking at income and expenses primarily and what the debts are and what the assets are, because the value of the assets also comes into play. In fact, that leads to the second thing that we can do. One of the requirements of a Chapter 11 plan is, over its lifetime, it has to repay the creditors at least as much as they would have gotten had the debtor done a Chapter 7 liquidation. Now, when a business does a Chapter 7, all of its assets are seized by the Chapter 7 trustee appointed to the case. The assets are liquidated, and then their trustee has money to distribute to the creditors according to certain priority rules that are listed in the bankruptcy code. So, for example, sometimes I'll have someone call up and say, my business is on the skids, I'd like to do a Chapter 7. Well, the first thing I ask is, okay, what are the assets? Oh, there are no assets. Well, then there's no reason to do a Chapter 7 for the business because there's nothing for the Chapter 7 trustee to do. And they'll say, well, I want to get the discharge. Well, businesses are ineligible to get a Chapter 7 discharge. So as a result, unless there are assets that need to be liquidated and the debtor just doesn't want to do the legwork of liquidating those assets and paying the creditors, Chapter 7 is not recommended for a business. For individuals, that's a different story, but for a business, no. Now, as I said, one of the requirements of the Chapter 11 plan is, over its lifetime, it has to compensate the creditors to the extent they would have been compensated in that Chapter 7 liquidation. Okay, well, suppose the debtor has assets that can be liquidated in the Chapter 11. So instead of doing the Chapter 7, because the debtor then loses a lot of control, everything goes to the Chapter 7 trustee, the debtor says, you know, I've got this piece of real estate. If I can sell that, it'll bring in enough money to pay the creditors. I'll be able to keep going with my future income having paid off a chunk of the debt. Then the future income will take care of the rest of the debt to the extent necessary to have a successful Chapter 11. So that could be what's called a partial liquidating plan. Then, of course, there is the total liquidating plan. You might think, well, wait a minute, why would I want to do that? I could just put the business into a Chapter 7 and let the Chapter 7 trustee do the legwork. Well, again, you are, when you're doing the total liquidation in Chapter 11, you're retaining control. And you lose all that control in the Chapter 7. And while there may be some Chapter 7 trustees listening, and generally I have very good relationships with Chapter 7 trustees, the dirty little secret is they're going to try to squeeze as much as they can out of the estate, because most Chapter 7 bankruptcy cases are what are called no asset cases, where the trustee gets just $60 for the entire case, whatever he or she does. So they live for asset cases. So as a result, in the Chapter 7, the creditors might not get paid as much as they would have gotten paid in the total liquidating Chapter 11 plan because there are no Chapter 7 trustee fees in that Chapter 11. So those are the three basic paths we take. We use future income, partial liquidation, or total liquidation to craft a Chapter 11 plan. Now, all of this doesn't seem to involve the creditors. And the fact is, sometimes if we can work with the creditors, we can craft a plan that they'll be happy with that doesn't just gut the business. So occasionally, we'll try to work with creditors prior to filing the bankruptcy petition in the Chapter 11 and maybe work something out so we know, well, look, this is what you want. This is what we're prepared to give. If we file this bankruptcy case and we propound a plan that gives you this, will you support us? And if you can line everything up prior to filing the petition, you can file what's sometimes referred to as a prepackaged Chapter 11. And that's very streamlined. And if you've got something like that, it really works quite well because everybody's already on board. Now, if you try to do the negotiation after you file the bankruptcy petition, there is a little bit of a problem, a potential problem, in that you're not supposed to be able to solicit support for a given plan until the judge has given the okay on the plan and a parallel document called the disclosure statement. So if you're going to do these negotiations, you want to do it early on before you propound the plan, or once the plan has been propounded, then you can talk to the creditors about getting their support. But then once you propounded the plan, if they say, well, you know, I really would have liked this in the plan, you might end up having to go back and recraft the plan ab initio. So rather than doing something like that, it's better if you can to work things out ahead of time and negotiate some sort of a resolution so the creditor sees, okay, I realize this isn't my ideal, but I accept what you're putting forward. And if you put forward a plan that has these conditions, I'll support it. That's, I think, a lot of what goes into the success of the plan. And I suppose you might say that it's a form of telephone law, where you call the creditor up, work with them ahead of time to see if you can't come up with something that everyone will be happy with.